Hello and welcome. Today, we're diving into a critical area of law, the forms of wills under the Philippine Civil Code. By the end of this session, you will be able to distinguish between the two main types of wills, identify the essential requirements for each, and understand the rules for wills made abroad. We'll cover the key articles, discuss common scenarios and issues, and provide practical tips for your studies and the bar exam. Let's get started. First, let's look at the general requirements for any will. Article 804 lays down the foundation. It states that every will must be in writing and executed in a language or dialect known to the testator. This means two things. First, a will cannot be oral. It must be a physical document. Second, the testator, the person making the will, must understand what they are signing. The language used must be one they are familiar with. Let's consider a scenario. Imagine a Filipino testator who has lived in Japan for 50 years and only speaks Japanese. If they execute a will in Japanese, is it valid in the Philippines? The answer is yes, provided they genuinely know Japanese. The law doesn't require the will to be in English or Filipino, only that the testator understands it. The issue would arise if the will was in a language they didn't know, like French, and they just signed it without comprehension. That would invalidate the will. Now, let's dive into the first major type of will, the notarial will. This is the more formal type, requiring witnesses and notarization. Article 805 outlines the strict requirements for its execution. Let's break it down. First, the testator must subscribe, or sign, the will at the end. This can be done by the testator themselves, or by another person in their presence and under their express direction. Second, the will must be attested and subscribed by 3 or more credible witnesses. This means they must be present and sign the will. Third, the signing must happen in a specific way. The testator must sign in the presence of all the witnesses, and the witnesses must sign in the presence of the testator and of one another. This is known as the presence requirement. To help you remember this, think of the acronym PAPA-DOBI. P stands for presence, A for attestation, P for pages, and A for attestation clause. We'll cover the last two next. Let's continue with the requirements for a notarial will. The second, P, in our PAPA acronym stands for pages. The law requires that the testator and the instrumental witnesses sign each and every page of the will, except the last, on the left margin. All pages must also be numbered correlatively in letters. This is a crucial safeguard against fraud. It ensures that no pages can be added or removed after the will is executed. The numbering and marginal signatures create a complete, tamper-proof document. Now for the final A, the attestation clause. This is a sworn statement by the witnesses, usually found at the end of the will, that they witnessed the testator signing and signed the will themselves in the presence of the testator and one another. The attestation clause must also state the number of pages used. If the attestation clause is in a language not known to the witnesses, it must be interpreted to them. This ensures they understand what they are attesting to. Let's look at a common issue with notarial wills, the presence requirement. The law says the testator and witnesses must sign in the presence of one another. What does presence mean? The Supreme Court has clarified this. Presence doesn't mean they have to be in the same room. It means they must be within the range of vision of each other. They must be able to see the act of signing if they chose to look. Consider this scenario. The testator is in a hospital bed. The witnesses are in the hallway, just outside the open door. The testator signs the will. Is it valid? Yes, it is. The witnesses could have seen the signing if they looked through the open door. The key is the ability to see, not the physical location. This is a crucial distinction to remember. Beyond the signing, a notarial will has 2 more requirements: notarization and special rules for disabled testators. Article 806 requires every will to be acknowledged before a notary public by the testator and the witnesses. This is a formal declaration that the will is their free and voluntary act. The notary public's role is to verify the identities of the parties and ensure they understand the document. The notary is not required to keep a copy of the will. Articles 807 and 808 provides special rules for testators with disabilities. If the testator is deaf or a deaf-mute, they must personally read the will. If they can't, two persons must read it to them and communicate its contents. If the testator is blind, the will must be read to them twice, once by one of the subscribing witnesses and again by the notary public. These rules are designed to ensure that disabled testators have full knowledge of the will's contents. What happens if there's a minor mistake in a notarial will? Article 809 provides a remedy. It states that, in the absence of bad faith, forgery, or fraud, defects in the form of attestation or in the language used shall not render the will invalid if it is proved that the will was in fact executed in substantial compliance with all the requirements of Article 805. This is a rule of equity. The law recognizes that minor, non-essential errors can occur. The key is to determine the testator's true intent. If the will was genuinely executed, and the defects are minor, the court can still uphold it. For example, what if the attestation clause says the will has 5 pages, but it actually has 6? This is a defect in form. But if there's no evidence of fraud, and the will was otherwise properly signed, a court might still admit it to probate under the principle of substantial compliance. However, this rule does not apply to the Meyer presence requirement, Hissa. That is a fundamental, essential requirement that must be strictly followed. Now, let's shift to the second type of will, the holographic will. This is a much simpler form. Article 810 defines it. A holographic will must be entirely written, dated, and signed by the hand of the testator himself. It is subject to no other form, and may be made anywhere in the world. Crucially, it does not need to be witnessed. The key here is that everything must be in the testator's own handwriting. If even a single word is typewritten or written by someone else, the will is invalid. This is a strict requirement. Let's use an acrostic to remember the requirements. HOLO. H for handwriting, O for omission of witnesses, L for location, anywhere, and O for one-man show. The testator does it all. While a holographic will is easy to make, proving its authenticity in court, a process called probate, has its own rules. Article 811 governs the probate of a holographic will. If the will is not contested, it's necessary that at least one witness who knows the testator's handwriting explicitly declares that the will and signature are in the testator's hand. If the will is contested, meaning someone is challenging its validity, the law requires at least 3 such witnesses. These witnesses are not the same as instrumental witnesses for a notarial will. They are simply people familiar with the testator's handwriting. What if there are no witnesses who know the testator's handwriting? The law provides a remedy. Expert testimony may be resorted to. A handwriting expert can analyze the will and compare it to known samples of the testator's writing to determine its authenticity. Holographic wills also have specific rules regarding additions, alterations, and multiple dispositions. Article 812 states that dispositions written below the testator's signature must be dated and signed by him to be valid. This prevents someone from adding new provisions after the will is signed. Article 813 addresses multiple dispositions. If a will has several dispositions signed but not dated, and the last disposition has a signature and a date, that date validates all the preceding dispositions. This is a practical rule to avoid invalidating an entire will for minor omissions. Finally, Article 814 deals with changes. Any insertion, cancellation, erasure, or alteration in a holographic will must be authenticated by the testator's full signature. This is another safeguard against tampering. Without the testator's signature, the change is invalid, but the rest of the will remains valid. Let's now discuss wills made abroad, a common scenario in our globalized world. Article 815 covers Filipinos in foreign countries. A Filipino is authorized to make a will in any of the forms established by the law of the country where they may be. Such a will may be probated in the Philippines. This is a rule of convenience. It allows Filipinos abroad to make a will without having to know Philippine law. They can simply follow the law of the place where they are. Article 816 deals with aliens abroad. The will of an alien who is abroad produces effect in the Philippines if made with the formalities prescribed by the law of the place in which he resides, or according to the formalities observed in his country, or in conformity with those which this code prescribes. This gives aliens abroad 3 options for making a will that will be recognized in the Philippines. It's a very flexible rule. Finally, Article 817 covers aliens in the Philippines. A will made in the Philippines by a citizen of another country, which is executed in accordance with the law of the country of which he is a citizen, shall have the same effect as if executed according to Philippine laws. So, an alien in the Philippines can choose to follow either Philippine law or the law of their own country. This is another example of the principle of lex loci celebrationis, or the law of the place of celebration. We're almost there. Let's cover the final 2 articles, which deal with a very important prohibition. Article 818 states that 2 or more persons cannot make a will jointly, or in the same instrument, either for their reciprocal benefit or for the benefit of a third person. This is a strict prohibition in Philippine law. You cannot have a dre, husband and wife, will, for example. Each person must execute their own separate will. The reason is to preserve the principle of meet revocability, ramen. A will is a personal act that can be revoked at any time. A joint will would make this difficult. Article 819 reinforces this. It says that wills prohibited by the preceding article, executed by Filipinos in a foreign country, shall not be valid in the Philippines, even though authorized by the laws of the country where they may have been executed. This is a key exception to the general rule that Filipinos abroad can follow the law of the place of execution. Even if joint wills are allowed in the foreign country, a joint will made by a Filipino will not be recognized in the Philippines. This is a matter of public policy. Let's test your understanding with a pass bar exam question. Here's the question. A will was executed by a testator who was blind. The will was read to him once by one of the subscribing witnesses, and again by the notary public. Is the will valid? Take a moment to think about it. Remember the special rules for disabled testators. The answer is yes, the will is valid. This scenario perfectly follows the requirements of Article 808 for blind testators. The will was read to him twice, once by a witness and once by the notary public. This ensures the blind testator has full knowledge of the will's contents. Let's try another one, this time on holographic wills. Here's the question. A holographic will was entirely written, dated, and signed by the testator. However, the testator made an insertion in the will but failed to authenticate it with his full signature. Is the will valid? Think about the rule for alterations in holographic wills. The answer is yes, the will is valid. The insertion itself is invalid because it was not authenticated by the testator's full signature, as required by Article 814. However, the rest of the will, which was properly executed, remains valid. The failure to authenticate only affects the specific alteration, not the entire will. Finally, let's wrap up with some essential bar tips for this topic. First, memorize the requirements for both notarial and holographic wills. Use the acronyms PAPA and HOLO to help you. These are frequently tested. Second, understand the difference between strict and substantial compliance. The presence requirement for notarial wills is strict, while other defects can be cured by substantial compliance under Article 809. Third, pay close attention to the rules for wills made abroad. Remember the general rule of Hong, lex loci celebrationis, and the key exception for joint wills made by Filipinos abroad. Fourth, practice applying the rules to scenarios. The bar exam loves to test your ability to apply the law to facts. Think about the why behind each rule. By following these tips, you'll be well prepared to tackle any question on the forms of wills. Thank you for watching.